Welcome to Looking at Legal Stuff. Today we have 13 hearings in the case of a high-conflict couple where mom has made a motion for contempt due to dad taking one of the children and not returning her after his visitation was over. In addition, mom motions for a show cause to change custody due to dad's recent DUI and OD. Dad claims mom is just being spiteful, but he's the one who can't control his anger and becomes hostile with the judge. Let's watch.
Okay, let's see who I have left here. Do I have Taylor Bondurant? Is it Taylor Flick now? Okay. And do I have Isaac present?
He is currently held in Columbia County Jail.
Okay, so let me pull up that case. This is 213-0019-408. So this was on, ma'am, on your motion for an order to show cause for a contempt hearing.
Yes.
And you said, excuse me, that I think the basis for that order was he had the children back on June 25th and had not returned them when he was supposed to. Is that correct?
Yes, because he gets them every other weekend. He didn't pick up Friday or Saturday. He picked up Sunday, and I told him they had to be back by 5:30 due to a court order. And then he didn't return them until July 2nd, so the following Sunday.
Okay. Certainly, I understand the basis for your motion. I would like him present to address the contempt order. So the child is back with you, correct?
Yes, they are.
Okay.
Yes.
Okay. Do you know when he may be released? Is he under sentence or is he awaiting pretrial?
Well, he got another DUI charge and some charge for his warrants that he could face up to a year. So I'm not really sure. He doesn't have an actual court date or anything yet.
He's being held.
Yes.
Okay. So here's what I would like to do is that you guys already have your final parenting plan. Has that been signed by a judge? It has. Okay. So really it's just the contempt on this issue right now as your primary issue?
Yes.
Okay.
We are going to court again, like sometime next month. Like I have a meeting with the lawyer and stuff, but this was the main concern, that he just sometimes will take them and keep them longer just to do it.
And you said you have another court date is it in this matter or a different matter?
I see the lawyer August 16th, so we don't have the actual court date yet, but it's about our parenting plan. Yes.
Okay. And is that, and it like you're thinking of hiring an attorney to change the parenting plan?
Yes.
I see. Okay. Let's do this. Let's set over right now your contempt hearing. I'm not going to deny the motion. Go ahead.
You need an order so that he can be served with that. He's not.
Oh, okay. He hasn't been served with the motion to show cause. Okay. Do we have an address for him? Or would we just use the last one we have on file? Okay. So you'll just need an order from me setting the court date. Okay. Oh, she hasn't served. Oh. Okay. So Ms. Flick, I'm getting to the bottom of what we may need to do here with some help from the court. Okay. So it doesn't look like from our records that you served him a copy of the motion and order to show cause on the contempt. Is that right?
Yeah. When I turned in the paperwork for the court, they just said it was like done. So I didn't know I had to be the one to serve him.
Yeah. So he does need to be served with this. And there should be the instructions on the on that page 2 of the document you submitted on the order to show cause, it does state that if you want the court to consider your side, you must. And then number 3 is have a copy of your papers served on all other parties.
Okay.
So what we should do right now is strike today's hearing since he hasn't been served.
Okay.
And when you can have him served in jail.
Okay.
That's an easy way to know where someone is. Once you have him served with whatever new hearing date you're wanting this heard on.
Okay.
Preferably when we know he's going to be available, but you know, I'll leave that up to you. So what I'm going to do today is strike today's hearing. I'm going to have you renote it for a new Wednesday at 9 a.m.
Okay.
and have him served. File that with the court. Then we know that he's been served and we can continue with the case.
Okay. Perfect.
Okay. Okay. Thank you for that.
Thank you.
And then,
Sorry.
nope, that's fine. And then the other thing I would say is if you do retain an attorney, they can do that process for you. So, and then that would be on a different represented docket.
Okay.
Okay. So I'm not denying the motion today. I'm just striking the hearing to allow you additional time to serve and set a new date.
Okay. Perfect. Thank you so much.
You're welcome. You are free to log out. Go to, I think I have Taylor Bondurant. And do I have Isaac Bondurant on?
I'm here. My last name's Flick now.
Did you say Flick?
Yes.
Okay. I'll just say the heading on the docket sheets they give us will always be under the filing name. So you'll probably have to correct me again on that. So my apologies. So, and this is 213-0019-408. I have Ms. Bondurant. I have Mr. Bondurant. Mr. Bondurant, have you received, you have, okay, you have filed a response to the commissioner's request.
I was out of town and my 11-year-old was served and I got it, I responded yesterday, but.
Yeah, typically it's supposed to be left with someone over the age of 18. So
yeah, it was left with my 11-year-old.
Let's not talk over each other. I'm hearing from Mr. Bondurant first. You're saying it was left with your 11-year-old?
Yes.
Okay. So my notes for personal service show that the process server left it with Melissa Betts, who they stated is a person of suitable age.
They had handed it to my 11-year-old and then she went and got Mimi, which is their grandmother, and then she had came out. But originally it was handed to. Well,
okay. So it's an important detail, sir. So the process server did confirm there was someone of a suitable age that was there to receive the documents. The date of that service was Monday, August 7th. Is that correct? August 3rd. Sorry. They filed the service on the 7th. So it was filed on the 3rd. It sounds, sir, is there additional documentation that you're wanting to supply before here's this motion?
Yes, I have a few notes I would just like to throw out there. I have.
Well, hold on. I'm not asking for the argument. I'm asking because you were served so close in time to the hearing. Are you asking for any additional time to file documents with the court?
Yes, Your Honor.
Okay. What do you expect those documents to look like?
I have the actual custodial, like we have 50-50. She has the old documents. She missed court dates in December 2021, and I was given 50-50 custody with no child support. And for whatever reason, the documents they have at Cowlitz County are not correct. I have the correct documents, and me and her have been doing 50-50 for 1.5 years. So yeah, I have all kinds of things. I have text messages. I've been kept from one of my children for now over a month. Okay, this is a whole mess, Your Honor. And listen, I got away from this. This is not the first time I've been kept from my children. I've done everything right as a parent. I have never came out her as a mother. She's a good mother, but what's going on right now is purely out of spite. And I have not got to see my child over that. and she hasn't got to see her 5-year-old because of that, because I'm too afraid to give up my daughter because she won't let me have them back.
Yep.
She's known for.
So, hold on. I'm just going through this. So I'm going to turn to Ms. Flick. You did originally file the motion for contempt hearing. Originally, because of timeframes, we would originally put that a month out to August 23rd. You did file a motion to shorten time. And the reason stated was essentially that you wanted to see the judge sooner, that you have some concerns about your daughter being returned to you, it sounds like.
Yes, she has been gone for 20 days from me and her sister. She was supposed to return after the weekend because we went back to our court-ordered every other weekend plan because of safety concerns, which I have a lawyer meeting next week about, so we could go back to custody court, but she has missed appointments. She's been gone for 17 and a half days from me and her sister, and they've never been apart. He has gone on road trips and left her with other people. And so he's not even spending time with her. And that's why we're going back to custody court for other safety concerns.
So let me ask, where's the child now?
I have her, Your Honor.
He has our oldest, and my mom took our youngest to her speech therapy appointment.
Okay. So, Mr. Bondurant, I understand that you want to file additional information with this court. I guess my concern in the interim is the only parenting plan I have in place is a 2021 parenting plan that states that children under school age are supposed to live with Taylor, except with you, sir, on weekends every other week. And then you also get them during week on days off.
Yeah, there was an updated one. She missed court. It was during COVID. I have the documents. And furthermore, Your Honor, we were co-parenting great for a year and a half.
Stop. I don't have that in my file. So what's the date of that new document that you claim takes precedent over your final parenting plan?
December 22nd, 2021.
And it says, order to vacate.
Ma'am, do you know what he's referring to? I don't have that in my file.
Your Honor, he's going off child support, what he told child support.
No,
he's going off child support.
No, we had a hearing, Your Honor. She missed 2 of the hearings and I was granted.
Are you saying that there's a new parenting plan in place with this court?
Yes, there was an order to vacate the old one because she didn't show up to court. And she knew all this. That's why we've done 50-50 for a year and a half. There's never been a safety concern. CPS was called to our house. They came in, they seen everything. They shook our hand. They apologized for having to be here. This is purely out of spite, Your Honor. I just want you to see that, please. I'm at fault in a lot of areas, okay? But I am not a bad father. This is a good household, okay? It goes so deeper than what's on the surface right now of things that have gone on.
Sir, are you saying, hold on, sir, on December of 2021, are you saying that you're able to file with me a court document that changes visitation?
Yes, yeah, I got it. It states 50-50. I can send that to you. I will go to the library today, get it printed out.
Ma'am, is it your statement to me right now that is not accurate?
Yeah, that's just what he told child support, and I didn't fight him with child support because I don't want his money.
Okay.
And it's not child support.
Okay. So here's what I'm going to do. I'm going to set this over 1 week. Mr. Bondurant, if we get to next week's hearing and what you have filed with me is not a parenting plan that changes custody, I frankly can all but guarantee you will be in contempt of this court based on what I'm reviewing in our file that does not allow you to have the child for this sustained period of time. But hold on, sir. I'm going to give you additional time because originally you should have had 30 days to respond to this. So I'm going to give you an additional week. You're going to be back on August 16th at 9 a.m. you have to have filed that new order or whatever document you're relying upon for your authority to have the kiddo for this sustained period of time. If I don't have that next week, or if what you filed doesn't actually say that, then we are going to be moving forward on the contempt motion. Okay?
Okay.
Ms. Flick, anything else right now that you need from the court? I know you were hoping to move forward today. I think there's enough question in my mind about what order we're really working off of. I want to make sure I have all the evidence in front of me. And then next week we will move forward on your motion.
Okay, I just have an appointment with my lawyer August 16th at 11. And like,
So
even if he was,
go ahead and log in, unless you want to push it to the following week to see if your lawyer would.
no, I want my daughter back. Like,
And
right away,
understand,
so-
Your Honor, I've gone just as long as and siblings have here without seeing.
Mr.
Lala.
Bondurant, you're having a real issue with talking over the court. Just wait, okay? Okay. So, ma'am, if your appointment is at 11, log on to this hearing at 9 a.m. and send a chat message stating that you have a lawyer appointment. You need your case called by 10 o'clock.
Okay.
Okay? And we'll make sure to get that done. And then, Mr. Bondurant, go ahead and file what you believe supports your position, and we'll move forward August 16th at 9 a.m. All right. All right. Thank you both. You're free to log out. I'm going to go ahead and take Taylor Flick, your case. And I just want to make sure I have you, I believe, under Bondurant from your original filing. Is that correct?
Yes.
Okay. And then I do have Isaac Bondurant on the phone ending in 7716. Do you want to go ahead and unmute, sir?
Yeah, I'm unmuted myself.
Okay. Okay, so this is 213-0019408. Let me just get into the digital file here. Okay. When we were here last, and I did receive some new documents just yesterday. I'll talk about those in a minute. But when we were here last, Mr. Bondurant, you did claim that there was a court order from December 2022 that superseded or changed the 2021 parenting plan. And I asked you to file those documents. And I got new documents from you, but it appears that it's not actually any parenting plan. It's just now your request for contempt against Ms. Flick. And that's, hold on, sir. And your motion for contempt, you've set on for the docket in 2 weeks on August 30th. So I guess let me first just be very clear and ask you a very specific question. I want a very specific answer. Have you filed with the court what you claim is a December 2022 order that changed the 2021 parenting plan?
Yes.
You have filed that. When did you file that with the court?
We got the last of the paperwork emailed to us yesterday. It was filed around 11:30 a.m. yesterday. At the same time, the contempt paperwork was filed.
I'm going to go back through what I was handed from yesterday's filing. I don't see that here. Ms. Flick, have you been served? Hold on, sir. Ms. Flick, have you been served with that document?
I have not.
Okay. Let me just check with the court. Would there be a way for someone to check if there are any other papers he filed yesterday?
We are still entering a few papers from yesterday. Let me see if anything's entered.
Okay. We're just gonna take a minute and double check, because Mr. Bondurant, I'm just essentially wanting to confirm if what you're telling the court is true, because I was handed several pages of your filing from yesterday, and it does not include anything that would even come close to being a new parenting plan.
There was a.
Yeah,
It's not.
there was about 80 pages that we filed.
Hold on, sir.
Was it-
Do you have access to that?
I don't, it is not scanned in.
Oh, because it's not scanned. Okay. Is there someone that would have that hard copy?
I don't know if it's in scan either, or if it's in papers too, we took papers into her trial, so she could.
Got it. Okay. Okay. And it states it's a declaration.
Filed by Isaac.
Okay. So, sir, tell me exactly what you filed yesterday, because our system is showing no one can see it because it hasn't been scanned in yet to my system, and I don't have a hard copy, but it's claiming to be a declaration. So what is it that you filed with the court besides your motion for contempt? Can you explain to me what it says and what it is?
It was a motion, there was a hearing, there was a motion to vacate the original parenting plan. And it stated in there that that the non-custodial parent, which was me, had the children 50% of the time. And there was a declaration signed as well, but that was like part 3 of everything that we sent in yesterday. Yeah, that was just explaining the documentation that we did file.
I'm gonna look one other place. I'm just not seeing anything here in I've pulled up your dissolution case number where they would have addressed the parenting plan. There's just nothing else in there.
I spent like 2.5, 3 hours there because there was some on the contempt paperwork. There was some issues where they just had us keep updating it and fixing it. But so I can speak for what happened to those documents, but they were filed yesterday at the same time as the contempt and the declaration. I mean, it was like 80 plus pages of documents.
Yeah, so you probably heard me tell someone who filed documents on Friday, filing them 24 hours or less before hearing is in no way going to guarantee or even, it is just not going to get to me. So I just want to be clear for everyone who's hearing this docket today. I know you all are unrepresented. I know that can make life difficult, but really the rules state you've got to file things 5 days before your hearing or the court doesn't have to consider it. Part of that reason is you've got to give the other side plenty of notice that documents are coming in and going to be relied upon. And again, we show up here, people say they have filed things and I have nothing in front of me. So, filing things a day before you come to court is not proper. I'm going to look at the original motion for contempt that Ms. Flick filed, which is what we're here on. Mr. Bondurant, you have filed your own contempt motion that's scheduled for August 30th. So we'll let that stand. But for Ms. Flick's motion, I know one of the questions I had at the last hearing beyond, hey, is there a new parenting plan, is where is the child? Ms. Flick, has the child been returned to you at any point since July 24th?
She has not.
Mr. Bondurant, what can you tell me about that? Because what you're telling the court is that there's a parenting plan out there that says 50-50. But if you're holding the child 100% of the time, you're still not complying with that order, even if it does exist. So what's up?
Okay, we had gone on the 24th, I believe it was, on my normal scheduled rotation for 50-50. We had went to her house, me and my wife. There was altercation, some issues. I was only able to grab Riley. I got her in the car, and she wouldn't give me Kinley. So that's kind of where we're at now.
Why are you?
I've also been.
Hold on, sir. Why are you keeping the kid 100% of the time? If the argument you're making to the court is best case scenario, there's an order out there that says you get her 50% of the time. You are unlawfully withholding the child at this point. Do you see that?
Yes. Isn't she unlawfully holding Kinley? I haven't seen Kinley for over a month.
Sir, not here on your motion. You scheduled that for August 30th. Okay, you filed that for August 30th. Here's what I'm going to do. I am going to set both of your show causes motion, both of the show cause motions for contempt to August 30th, because I want to see what you did file yesterday before I rule on contempt. But what I am going to say, and what I am going to put in a bench order, and Ms. Flick, let me know, if this is doable for you, but I do want the child returned to Ms. Flick by 3 o'clock today. Ms. Flick, I don't know if we can work on that time. I don't know what your work schedule is. Let me know.
Yeah, that's perfect. I just want her back today. And I will say, I know it's for a different day, but the reason he doesn't have Kinley, and I have a recording of him saying it when he grabbed our oldest, he said, I got one kid and you got one kid and you won't see this one again.
Yeah.
So that is why he doesn't have Kinley.
And Mr. Bondurant, I also, in looking through your case history, see that you've got some other stuff going on where you've got restraining orders against you from July.
It was a conflict I had with a neighbor across the street that has no bearings on my children.
Okay, well, all right. So here's my ruling. I'm going to fill out a bench order today requiring Mr. Bondurant that, and make sure I put the right child's name in there. Ms. Flick, can you spell it for me?
It's RYLEIGH and then Bondurant, BONDURANT.
Okay, Riley, sir, must be returned to Ms. Flick by 3 p.m. today.
And ma'am, what about Bondurant? When am I going to see my other daughter?
That's not in front of me. Your motion, you filed a motion for contempt on that issue. You scheduled it for August 30th. I'll deal with it on August 30th.
So I don't get to see my kids up until that point?
Sir, that's when you asked the court to hear your motion.
We have done 50-50 for a year and a half. We've done 50.
Mr. Bondurant, what is before me today that you were on notice of since our last hearing was withholding Riley from Ms. Flick. That is what is before. That's the only thing, sir.
I had 5 days to get all those documents.
I will
wasn't
mute
given
you.
an adequate 30.
Okay, here's something that people don't understand. We're on Zoom, but this is still a courtroom. I am speaking and issuing my ruling. I will ask for questions when I am done, sir. What I am telling you procedurally, the only issue in front of me is Riley's placement. You, sir, have asked me to address the other child, and you've asked this court to address it on August 30th, and that is when I'm going to address it. You didn't ask for it to be addressed sooner. You asked for it to be addressed on the 30th. My ruling today is that I'm going to set over the ruling on the contempt motion by Ms. Flick to August 30th so I can review what you filed yesterday. But in the meantime, because everything in front of me shows best case scenario, you have 50-50. That's very best case scenario. You have 50-50 time. and you haven't given Riley back to Ms. Flick since July 24th or so, you are to return her by 3 p.m. today. If you do not, Ms. Flick, please note on our motion docket for next Wednesday, a new contempt motion, and we will address it on Wednesday.
Okay.
All right, anything else on this matter? Mr. Bondurant, do you have questions for the court?
Not that you'd answer for me. I'm all right, thank you.
All right, we'll see you both back on September 30th. I will be filing that order at the end of docket today.
You said September 30th, or did you mean August?
August, I'm sorry, August 30th.
I just wanted to make sure.
Yes, August, 2 weeks.
Okay.
All right, thank you.
Thank you.
First, what I'm going to start with, I see a couple attorneys online. Let me start, Ms. Bliss, with you, since I did see a notice of appearance come in on the Taylor Flick and Isaac Bondurant case. Is that correct?
That is correct, Your Honor.
So, this one on my docket is number 8, 21300194008. And do we have Ms. Flick or Mr. Bondurant with us as well?
I'm here, Your Honor.
Yes, my client is present.
Let's see, we have a couple people logging in. Let me admit the waiting room here. Do we have Isaac Bondurant present?
Yes.
Okay, that's you, the number ending in 7716.
Yep.
Okay. So, on Monday, we did receive notice of appearance of an attorney in this matter. Ms. Bliss is online. And my instructions in these types of situations is to get you guys set to the represented docket. Is there any objection to that, Ms. Bliss?
No, Your Honor, I did just notice that there's also a hearing scheduled next week in front of Your Honor, so I would just ask that that gets set over as well, if Madam Clerk can do that.
Okay. Let's log in here to give me a second just to get your digital file open. Mr. Bondurant, are you expecting to retain counsel at this point?
Yes.
Okay. So which docket would we be putting them on?
They would be on A.
Okay.
Which would be Tuesdays at 9.
Okay, and let's see, so you'd be family law docket A, which will be our Tuesday docket at, is it 9 o'clock or 1 o'clock?
9 o'clock.
9 o'clock. What's the next available?
So there is room on Tuesday, the 29th.
Okay.
Um,
So it does sound like our docket for next Tuesday, the 29th, is still open. Ms. Bliss, I know you're just on board. Are you asking for more time than that, or do you want us to get you on the Tuesday docket?
Your Honor, Tuesday, the 29th is perfectly fine. I got up to speed this morning in preparation to move forward today, but I understand Your Honor's intentions of moving us to the attorney docket.
Okay. And then Mr. Bondurant, would you be available? We'll move this hearing to Tuesday, August 29th at 9 a.m. You would be logging on by Zoom as well.
Yeah, I'll be available.
Okay, if you do retain counsel, have them put in a notice of appearance as quickly as possible. Otherwise, you can address any requests for additional time when you're in front of the judicial officer next Tuesday, okay?
Okay, in the meantime, so I haven't seen still one of my kids in a month and a half, and Friday's coming up. I'm supposed to be retaining my children. So how's that gonna work? I do not feel like I should be going all through these court dates without seeing my kids.
So I'm moving you to next Tuesday. I'm not going to be taking any action on the case today, and you can address that with the judicial officer on Tuesday.
I do want to ask, because my ruling last week was that that Riley be returned last week. Did that occur?
Yes, Your Honor, I do believe
That-
that occurred right after the hearing.
Okay. And then you also have the motion for contempts, both motions for contempts on for August 30th. We'll move that motion also to August 29th. Will that work for the court?
Yeah.
Okay, so we'll get both of those, today's proceeding and your August 30th proceeding, both consolidated into next Tuesday, the 29th.
Very good. Thank you, Judge.
All right, thank you all. You're free to log off.
Is here representing Mr. Bondurant, and we'll see if Taylor Flick, it looks like she's on the line. Miss Flick, can you hear me?
And Your Honor,
Yes,
Ms. Flick
I
is
can
actually
hear
compliant.
Okay, all right, great. All right, so this is Ms. Flick, this is your motion for contempt. And I'll double check, see if there's any concerns related to service. Ms. Bliss, any concerns?
No, Your Honor, and just for the record, I do represent Ms. Flick. I know we were both speaking over each other. I want to make sure you understood that.
Thank you. Thank you. Yeah,
Perfect.
my notes have that accurately portrayed, so I appreciate that. And then, so Ms. Flick and Ms. Bliss are here as a team, as if you will. And then I'll ask if Isaac Bondurant is present. Isaac Bondurant, are you here? All right, thanks. Let me just pull up.
And I will just note, Your Honor, we've been in front of Commissioner Carmi, I believe. They were in front of her, I think, 2, maybe 3 times before my involvement. And then we were in front of her last week when she sent it over to this week's docket. Mr. Bondurant had been present at every hearing, had accepted service or indicated that he did receive service, filed several responsive declarations to the motion. I'm frankly surprised he wasn't here. I do know there was some traumatic medical issues, to put politely, last week. So I don't know if that might have any indication as to why he's not here.
Okay. And those medical issues involved him?
Correct. Last I had heard, he had been released from the hospital on Friday or Saturday. So I don't imagine he's still in the hospital, but I do know that he was taken to the hospital last week.
Okay. Yeah, and it looks like as far as the minutes, he had been present for multiple hearings prior. And then just want to just double check was that there was an order, I think last week or 2 weeks, that the daughter, I believe one of the daughters would be returned by the 16th of August. Did that happen?
Yes, Your Honor.
Okay. All right, good. Well, let's do this on the off chance that he's running late. I'm just wondering if the parties would be willing, if I've got one other case besides this one, if you mind if I take that case and then return to this one.
That's fine.
Any communication by chance from Mr. Bondurant?
And I had just looked at my email and I have not received any response from him. I checked with my staff downstairs. There's been no phone calls from him this morning.
Okay. And it looks like, in just reviewing on the motion for contempt, I didn't note that there was, well, he filed response, and so, and he's not here. So, based on his non-appearance, and he may come back later on and say something happened, and we can address that then. But at this time, where the pleadings, I think, clearly established that there is contempt related to the parenting plan. The parenting plan is from alternating Fridays, 10 a.m. to Sunday at 5:30 p.m. And some of the language there was a little bit concerning. It was a bit squishy, where Isaac can get the children during the week on days off if we have no plans. Yeah, anyway, so the allegation is that Mr. Bondurant has failed to return. I'm not sure if it's Kinley or Riley. I think
it's Kinley.
Kinley since June. Pardon me, since
or Riley. Sorry, the older child.
Okay, so it's Riley since July 23rd, Sunday, and Mr. Bondurant raised some issues. I mean, he had some thought that the parenting plan was 50-50. I think he got confused when he was looking at the Division of Child Support order that he talked about that a little bit, at least addressed it. I think that's where some of the confusion, hopefully he was going to be here so we could address that. But So I think given that, I'll make a finding of contempt of that against Mr. Bondurant for failure to return the child since July 23rd. And I'll turn to Ms. Bliss to see if you have other requests related to that.
I know my client had filed this motion pro se. I would just note that I've appeared at 2 hearings on her behalf. I don't think she is precluded from asking for attorney's fees at this point, so I would make that request, understanding that the motion was filed pro se prior to my involvement.
Okay. I'll impose $500 of attorney fees. And I have a proposed order that Ms. Flick submitted. Ms. Bliss, have you seen that?
No,
Okay.
I have not seen that.
All right, so let me just take a look here. So I'll put a civil penalty of $100, and I'll put this is Mr. Isaac, and the creditor, her name is Ms. Flick. And then lawyer's fees, I'll add the 500. I don't need to take your time here. I'll fill that out, and then I can get that filed. But I am making that finding of contempt, and I guess if something was amiss with his health, we might hear about that in the future, and we can readdress things and take a look at it fresh.
Absolutely. Okay. Thank you, Judge.
Great. I'll get that filed. Thank you.
The Taylor Flick and Isaac Bondurant matter, which is cause number 21319408. There we should have, I believe, Ms. Bliss is present. She represents Taylor Flick. Ms. Bliss is present. And is your client present, Ms. Flick?
Yes, Your Honor, I do see her present on the Zoom call today.
Great. Thank you. Welcome to you, Ms. Flick. And then Isaac Bondurant is the respondent. Mr. Bondurant, are you on the line today?
Yes, Your Honor.
Okay, welcome to you. We're here, pardon me. We're here on a motion brought by Ms. Flick, and a motion for finding of adequate cause to change the parenting plan related to that, adjustment of child support, and also a motion for a restraining order, and a motion on temporary orders. So that's why we're here. I just want to touch base before we get going with Ms. Bliss as far as service. I see that Mr. Bondurant was served on September 8th for the parenting plan and adequate cause modification issue, which was not 21 days prior to today. And then as far as the restraining order, it looks like he was served on September 7th, which would be within the 14-day period from then until now. So just wanted to get your take on that before we get started.
Correct, Your Honor. And I think I'm happy to, well, first and foremost, Mr. Bondurant didn't file any sort of response. So obviously that may hamstring us before we move forward today. I think my intention was to have both cases heard at the same time for obviously judicial resources, my client's resources, and the like, knowing that we had that 14-day timeline for the restraining order. I did put all of matters on for today with the expectation that if it needed to get set over, it could get set over. But obviously those timelines, especially on the restraining order, are pretty stringent. So.
Okay. All right. Thanks. So, Mr. Bondurant, I just want to touch base with you. Looks like you received some paperwork from Ms. Flick's attorney on the 7th and 8th of September, and I wanted to touch base to see if you had filed anything or what your kind of where you're at with filing a response.
Yeah, I'm still working on it. I would like to ask for a continuance. I have extensive evidence on my part that just hasn't been able to be heard. And I'm still going, so I would like to ask for a continuance, please.
Okay. And then as far as a time frame of how long to continue this, we could look at probably a 2-week continuance would be proper, because if there's a response filed, then Ms. Flick and her attorney will have opportunity to reply to that. So I'm looking, that would put us to October 10th. And so I'll ask what the parties think of as far as October 10th, Ms. Bliss.
I don't have any objection to that. I would just request that the immediate restraining order be extended until that point.
Okay.
On what grounds is this restraining order being put in place, Your Honor?
That's a good question, Mr. Bondurant. In reviewing the case, I saw that there was a motion for what they call an ex parte or a one-sided input restraining order until a hearing can be heard on the matter. And that was entered on, I believe, September 5th. That was signed by Judge Basher on September 1st, it looks like, and that was based on a declaration that was filed on or about that same date of September 5th. It relates to, it looks like it's a 5-page document as far as the declaration, and then there's supporting documentation related to, and I can just share a little bit of this information with you, concerns related to cocaine and fentanyl use, and also an overdose and being revived with Narcan, concerns related to a DUI arrest happening on July 6th, and concerns related to a revocation of a prior deferred or diversion agreement on a similar charge, and concerns related to drugs and sales of drugs, and concerns of comments made about one parent to the child. So that looks like that was the basis of that immediate restraining order.
Could I respond to that, a few of those things, Your Honor, just real quick?
You can, but not today, because that order is in place. And so it's in existence.
Okay, I'll just, CPS already has all the documentation, and I'll be able to provide supporting my case on this end. And I would also just like to respond, the DUI we're referring to is a DUI I was charged with when I was still married to Taylor Flick. I was just taking care of an old warrant I had on it. So that could be scratched off there.
So yeah, I mean, with immediate ex parte restraining orders, it's obviously, like I said, it's a one-sided input, and so
yeah,
having your voice heard is super important, and that will happen if your schedule allows on October 10th. So I'm granting your wish to continue the hearing so you can have opportunity to submit your documents, and I'm just curious if October 10th works for your schedule.
Okay. Also, Your Honor, that sounds perfect to me. I will be ready on that date. I would also like to, if you could put in the notes that I would like as soon as possible to have a guardian litem.
That's something that is certainly in your response when you submit your response or your view of the situation. That would be something that you could make motion of or make mention of in that paperwork also, so it's documented.
Okay, thank you, Your Honor.
So I will continue the matter to October 10th, Tuesday at 9 a.m. I will also extend the temporary restraining order that was entered on September 5th. We'll continue that out to October 10th. I'm going to double check to see if on my bench here I have some documents that will do that. So bear with me just one moment. Madam Clerk, is there a specific order that we have, or is it something I could just do a bench order? Or is it better to use a specific document?
To use a specific document.
Yeah. So I'll tell you what I'll do. Once we're done with the docket, I will find the appropriate document that I'm looking for that extends the existing ex parte immediate restraining order until October 10th, and I'll file that.
Would it be easier for Your Honor? I did prepare for when the case began, I did prepare an immediate restraining order for this matter. Would it be easier for Your Honor if I forwarded that to you for signature and just simply put extended on there? I think that's typically how we do it when we extend them. Or if you want, obviously, if you want to prepare your own order, that's fine too.
You know, if somebody's willing to do work for me, I'm happy with that.
Okay.
So yeah, if you could do that, and if you could also include Mr. Bondurant in that distribution, so he knows what's being presented to me, that would be appreciated.
Mr. Bondurant, do I have an email address for you so I can include that in?
An email, please. No, you don't, but I can give you one.
And that was M as in Mary.
Yeah, that's what it said.
Okay. I will include that with an email to your honor.
Great. I'll look forward to receiving that. And if it's in proper order, I'll go ahead and sign off on that and file that. And then we will then look forward to having Mr. Bondurant's pleadings submitted to the court and filed and shared with the opposing party. And then we'll be back here on October 10th to hear those issues and make some decisions.
Absolutely, Your Honor. I look forward to it.
Ms. Bliss, do you have any final issues?
The only issue I have, Your Honor, is since we did set that 10th date, I would just ask that maybe Mr. Bondurant's pleadings be filed by Monday at the latest, so I can get a quick turnaround reply if I need to.
Yeah, that's not ample time for me. I need more time than that. I'm sorry.
Well, then I would ask we go beyond the 10th.
I'm working without a lawyer, so I'm doing this all on my own. I'm going to go through CPS, child support. So I'm gonna need a little more time than that. I appreciate it though.
How much more time do you need?
2 weeks, please.
So 2 weeks. So you're asking then for your response to be due on the 10th. And then if that was the case, Ms. Bliss, then the hearing would have to probably be on the 24th or the 17th.
That would be my request. Either is fine. Obviously, I'd prefer the 24th so I could get a turnaround less than a day or two, but I'll defer to the court on that.
Okay. So Mr. Bondurant, as far as like I'm fine with extending and giving more time to get documents in to the court and to the other party. So that would put the 2 weeks would be the 10th. That would be the date you'd need to have your stuff filed with the court and distributed to the other party. And then we'd be back here on the 24th of October to hear everybody's argument. So we would not be gathering on the 10th. That would just be the date for your submissions. And then, but we would gather on the 24th to hear the argument from the parties. How does that look?
That sounds all right, Your Honor. I appreciate you.
Okay. All right, Ms. Bliss, that sounds like that's agreed. So we'll strike the 10th as the date that we're gathering and move that to the 24th of October at 9 a.m. And we'll have Mr. Bondurant's response to the pleadings due on October 10th.
Very good. Thank you, Judge.
Okay. Any final questions on the case at this point?
No, sir.
Okay, great. That'll
Nothing for
conclude
me.
the case for today. Thank you.
Thank you.
Okay.
And Judge, I have 6, 7, and 8, the Flick and Bondurant matters. I'm going to be asking for a continuance today anyways. I did receive Mr. Bondurant's pleadings Wednesday of last week, despite the fact that Judge Evans indicated they were due on the 10th. My client simply didn't have the opportunity to provide a reply. And given the court's calendar today, I think it's probably appropriate too, given the length of argument needed for that case. The only issue is there is a current temporary restraining order in that matter, so that will need to be extended 1 week. I've already drafted that as of the last hearing, so I can simply just plug in a new date and send that over if that's agreeable.
So Mr. Bondurant, are you able to hear the court?
Yep.
Okay, so it sounds like you did file some additional pleadings. They're asking for additional time to respond. We're inclined to set this over 1 week because of that, but also because of this other issue I've let all the parties know about. Are you in agreement with that?
Yes.
Okay, so we'll set you to October 31st at 9 a.m. And then Mr. Bondurant, just so you know, I will go ahead and sign off docket a 1 week extension of the restraining order. Okay, so that'll be good through the October 31st hearing. Do you understand that?
Yeah, I can hear
Okay.
you just
Just
fine.
wanted to make sure that you knew that was happening. Okay, we'll see you back next Tuesday. Thank you for your cooperation.
Fuck
Thank you,
you.
Judge.
Thank you.
All right, next I want to take Taylor Flick and Isaac Bondurant, 21-3-19408. There we have Ms. Bliss representing, yep, there she is. Ms. Bliss is present representing, pardon me, Taylor Flick. And is Isaac Bondurant on the line today? Isaac Bondurant?
Yes, sir. I'm here.
Okay, welcome to you, Mr. Bondurant. Give me just one moment as I pull up my notes, and I apologize. Okay. This is comes before the court on Ms. Flick's motion for adequate cause to modify a parenting plan. We were here before and Mr. Bondurant asked for some additional time, and I've read his pleadings. And so I think we're ready to go. I'll hear from Ms. Bliss and then from Mr. Bondurant, please.
Thank you, Your Honor, and for the record, Carly Bliss on behalf of petitioner Taylor Flick, who is the moving party before Your Honor today. As Your Honor summarized, we are before the court on my client's request for a modification to the parenting plan. There is also a request for a restraining order. Both have been heard by the court or reviewed by the court, I imagine. One question preliminarily, did Your Honor have the opportunity to review my client's reply declaration that was sent over very late? It was yesterday. So there is that issue.
Yeah, let's see. I wasn't in the office at all yesterday. So I was handed some proposed orders. So I think the answer is no.
Okay, and that's fine. I have no issue proceeding regardless. There was some objection that I contained within that declaration. So I would just note those for the record as well, for Your Honor. Mr. Bondurant provided my summarization of nearly 100 pages of responsive declarations, pleadings, exhibits. I don't know the exact number off the top of my head, but there was significant statements provided. I would note that his responsive declaration was, I believe, 27 or 28 pages, single spaced. Obviously, that goes beyond Local Rule 88. Also contained within his pleadings were exhibits which appeared to have been declarations prepared by other folks, not sworn under penalty of perjury. Obviously, those are inappropriate as well. So I would ask the court to not consider any of those pleadings. Further, I did make a request that the court not consider any of the pleadings provided by Mr. Bondurant, given the fact that Your Honor did give him a firm due date of October 10th. Those were not provided to the court until October 17th, nor provided to my office until October 18th. So those are my preliminary requests today, obviously deferring to Your Honor. If I need to go into more argument, I'm more than happy to, if Your Honor is going to consider any of his pleadings.
No, that's fine. Thank you. So let me just touch base with Mr. Bondurant. Mr. Bondurant, there is your submission that was filed on October 17th. And it looks, I counted 26 handwritten pages of basically your statement. And then you had a declaration from another individual. And so there's page limits that are which kind of makes sense, because when I get a 149 page pleading just for one setting, for one case, that's a lot. And as you've seen today, there's about 20 cases on today. So there's necessarily some time constraints. And so those rules are in place to say, hey, look, we've got some page limits here. And so what I did, I kind of gave you the benefit of the doubt. You submitted 26 pages of your declaration. I stopped reading at 12. And then the other individual, they needed to make their declaration under penalty of perjury. And that gives the person kind of, puts them on notice, like, hey, what I'm saying here is really important. I have to be factually correct. And that was absent. Their reply didn't have that. Secondarily, their reply was too long, needs to be limited also. So I read a portion of that and then I stopped because it was beyond length. But Ms. Bliss raises a good point as far as the under penalty of perjury language being absent. So I just want to give you a voice to that issue. So if you want to address that just briefly, Mr. Bondurant, you can.
Yes, Your Honor. What I can say is I'm not an attorney. I have no skill in that department. I do know it's very hard to summarize. I mean, to you guys, it seems 26 pages seems like a lot when it comes to your children, but that was the beginning. I mean, these kids are my whole world. So that was easy to sit down and write this about my kids. I mean, and if, Your Honor, if all you were able to get through was 12 pages of my declaration, but you were able to see all the pictures, it's clear to see who I am as a person, what's being pressed that is incorrect. It's stuff to just diminish my name. All this can be proven. I have proved all of it. She said I was pulled over for a DUI, probably on drugs. I
So we
proved
won't
that.
go to the kind of the specifics. I just wanted to just give you just a voice on the issue of kind of the overlength. So I've kind of told you where I'm at, and so that's great. I appreciate that. You'll have opportunity to discuss in detail your concerns. So I'll turn the time to Ms. Bliss.
Thank you, Your Honor. And before the court, obviously, is my client's petition to modify the parenting plan, given the significant concerns my client raises in her declarations. I note at least 6 different major issues that she reports in her declaration to give rise to this motion and this petition. Looking first to the DUI, my client provides in her declaration and within her exhibits. At that point, all she had available to her was a screenshot of the booking information, and that is contained in my client's, I believe, Exhibit 1 of her initial declaration, indicating Mr. Bondurant was arrested in Springfield, Oregon, or thereabouts, under the suspicion of driving while intoxicated. My client raises significant concerns regarding this, as Mr. Bondurant had also had a DUI back in 2016, to which he was on diversion for. I understand that his diversion has since been revoked and his license has been suspended. On that same vein, my client provides significant concerns. There are video and photographic evidence of Mr. Bondurant continuing to drive with the children, continuing to drive while smoking marijuana, continuing to drive with the children not in proper safety restraints, not in booster seats, in the front seat, on his lap, and the like. The fact that Mr. Bondurant fails to protect these children, these very tender age children, ages 5 and 4, to that extent, is just the tip of the iceberg. Very concerning. It's my understanding that his license has since been suspended. My client is requesting specific language that prevents Mr. Bondurant from driving these children at all, at least for the foreseeable future, especially given the suspension, especially given his attitudes towards the suspension. My client provides that he is very active on social media. I think even his responsive pleadings indicate this. If Your Honor were to review any of the videos provided regarding this issue, it's very telling that Mr. Bondurant is defiant towards authorities, is defiant towards court orders. Obviously, driving while intoxicated speaks volumes for itself. Looking next to the verbal aggression, derogatory statements, and the like made towards my client, not only in front of the children, which is disturbing enough, but also, again, on social media, referring to my client in very derogatory names. My client provides there's one specific incident back in July when Mr. Bondurant and his wife came into her home to retrieve the children, started screaming profanities at her, calling her a effing bee in front of the children. Again, these are very tender age children. This behavior is completely inappropriate, and there does need to be some limitations contained in the parenting plan that prevents this from continuing. Another issue brought forth in my client's declaration and is very concerning is the overly sexualized behavior that is being exposed to the 5-year-old child in this matter. There's discussion in there regarding the 8-year-old stepchild of Mr. Bondurant French kissing the 5-year-old in this matter, grabbing her face, not letting it go. My client indicates she's questioned by their 5-year-old what French kissing is, why her sister had done that. And Mr. Bondurant's statements are essentially dismissive, that never happened. Why weren't the police called? My client provides in her responsive pleadings filed yesterday that the police were called, CPS were notified. It's her understanding there are active investigations regarding that issue. But the fact that it is so dismissive leads my client to believe either Mr. Bondurant's household is condoning that behavior or they're simply just not supervising these young children, both of which are equally as concerning. Obviously, there was a contempt brought forth before the court to have my client retrieve the child. Mr. Bondurant kept one of the oldest child, for upwards of a month and refused to return her, but for that contempt motion being filed. Obviously, that is deeply concerning. My client also provides for the court the continued detrimental statements being said to the child. Upon receiving the child from Mr. Bondurant, the child expressed fears, nightmares, saying that daddy and mommy Courtney were going to kill my client, drown her in the river. These are very concerning statements, again, for any child, especially a 5-year-old child. A child that is now expressing fear having to go back to her parents' household, given those significantly concerning statements. And lastly, but most concerning, was the overdose in August. My client provides for the court that she was notified, did independent research to learn that Mr. Bondurant and his wife consumed fentanyl-laced cocaine. I see in Mr. Bondurant's responsive pleadings, he indicates it was a fentanyl-laced joint, marijuana. However, also contained in my client's reply declaration is there's ring cam footage from the date that Mr. Bondurant was released from the hospital, came to my client's home, indicated he came to quote unquote show the children that I'm not dead, and he went over to a home and did a little bit of cocaine that, unbeknownst to him, was laced with fentanyl. Again, the minimization of drug use, whether it's legal substances as marijuana or illegal substances as cocaine and fentanyl, both are equally concerning. My client provides significant documentation regarding the marijuana usage. Mr. Bondurant holding up bags, gallon bags full of marijuana. Again, whether it's a legal substance or not, the children should not be exposed to that. My client has concerns that there is some illegal activity within the home, selling of drugs. Obviously, the usage of cocaine and fentanyl, either at Mr. Bondurant's home or his neighbor's home. The circumstances surrounding the overdose are equally as concerning. Obviously, if he was allegedly at his neighbor's home, started to feel unwell, as he put it, was leaving said home and essentially collapsed outside of his home. Narcan needed to be administered to save him. He was rushed to the hospital, was in the hospital for a period of time. All of this is deeply concerning, and the fact that Mr. Bondurant is minimizing the effects of not only this on his life, but on his children's life, who could have been exposed to this. There were children, my client's understanding, within the home when this incident occurred. Again, having this type of drug use with these tender-age children and not having any sort of safeguards in place are very concerning. So the request before the court today, from my client's perspective, is to either suspend visitation, which is currently the status quo with the restraining order, or require professionally supervised visitation pending a substance abuse evaluation. I note in Mr. Bondurant's responsive documents, he indicated, oh, he's in some sort of treatment or is undergoing some sort of UAs, hair follicles. None of that has been provided. So there's no way to determine if there is any sort of sobriety. He claims, oh, they only tested positive for marijuana. Again, my client would argue that's also inappropriate, especially given the tender age nature of these children. But frankly, there's nothing to substantiate any of his allegations or any of his claims to prove otherwise. So what there is before the court is substantial documentation, substantial photographic video evidence that there are some significant issues here. So we are asking the court to find adequate cause to modify the parenting plan, given the various concerns I've just provided and recapped. I think a guardian ad litem is probably appropriate in this matter, especially given, again, the tender age nature of the children, the severity of the concerns provided. And that is, we're asking the court to order professionally supervised visitation pending that substance abuse evaluation, pending proof of sobriety, and pending a further word from the guardian ad litem.
Thank you, Ms. West. Mr. Bondurant, I'll hear from you, please.
Yes, so I guess I'll start with the overdose. That is still active, an active investigation. The story behind that, our kids were not at the house. My wife's mother was here. We had gone over to my friend's house, and yes, we smoked a legal joint, which is we are allowed to do. It gotten passed to us, and it happens all the time. Talked to him at the hospital. Somehow it was laced with fentanyl. The guy's vehicle was impounded. He had belongings taken from him that day. I did not. They were allowed into my house and they found nothing. This is an investigation into a poisoning. Okay, that is all that is. And that is public information if the lawyer would do her research, on top of the fact that, excuse me, this is being taken. She's trying to paint a picture like I'm just this terrible human individual. That is not the case. She references me being a drug dealer, me holding up gallon-sized bags of drugs. My friend, he grows for a dispensary, and it was 2 Ziploc baggies, approximately about a pound of marijuana. And I took a picture of it. I also have a TikTok where I goof off. I portray myself to be one way. It's social media. You can be anyone you want to be, okay? And they're just trying to spin any video they can, anything they can against me to paint this picture. Oh, also, my arrest, she's referring to the DUI. I was arrested for a warrant for an old DUI when I was still actually married to Taylor Flick. I just hadn't taken care of it. So when my wife got pulled over, they ran my name because she has a protection order against her ex, and they had to make sure I wasn't him. And it came up that I had a warrant out for my arrest. So I was arrested, taken to Lane County Jail, and extradited back to Oregon. I have since taken care of all that. I'm not on probation. I'm not wanted in Oregon. And as it pertains to video evidence of me driving around with my kids and not in car seats and not safetied up, that is also not the case. These are pictures of just sitting in a car, a stationary car, and I'm doing TikToks and I'm taking pictures with my kids. I do not smoke marijuana in the car with my kids. My wife drives 99% of the time. I haven't gotten behind the wheel in 4 months, especially after my arrest. I definitely don't play around with it because yes, Your Honor, I am revoked. There's so much that is being portrayed in these by Mrs. Flick. The day that she says that names were called, we actively called the police on her. Her mother assaulted my wife. And because it was 3 against 2, the charges went nowhere. I don't even know, again, I'm not an attorney. I probably sound all over the place. I don't get paid to be an attorney. I'm just a dad that's trying to make sure he doesn't get railroaded by the courts on something that a picture is being painted that any amount of looking into, you could see the truth. In my exhibit, it might have had a lot of documents, but if you read the whole thing, which I'm sorry you didn't, it states everywhere. She's making claims against me. I'm proving myself. That's what it says in there. That's what these pictures are. The CPS when CPS was here, the CPS case has already been closed. It's been closed for about a month and a half. We're just waiting for the paperwork, and we'll be able to show the courts that I am in treatment, and it's not for cocaine use because I've never had a cocaine issue. I had my appendix removed. I had surgery, and I was on pills, and then I did for a while there. I did get out of hand with pills, so I made sure on my own I went into Ideal Options and sought treatment. And I've peed clean because I don't do drugs. I will submit to a hair follicle. That's fine. And a guardian litem. That's fine. I'm not a super good talker, Your Honor, but with people actually coming here, CPS knows who I am as a father. Taylor knows who I am as a father. This is purely out of spite. And unfortunately, we're in Washington State and I'm a father here, so we know how that goes.
How does that go? I don't know how that goes. How does that go?
I won 50-50 custody of my children. She didn't show up to court. Okay. I was awarded 50-50 custody for a reason. Because I am a stand-up dad. Because I provide for my kids. Because I protect my kids. That's who I am as a father. Taylor knows that. And at the end of the day, the courts are going to make whatever ruling they want to make. I haven't seen my girls in almost 4 months. And you guys are expecting me, the courts, Taylor, anybody expecting me to live any kind of a normal life when the only piece of normalcy I have, she's been able to take from me on a whim. This is not the first time she's done this to me. Anytime I have anything to say or I stand up to myself, this is the situation I get put in. Okay. We don't get to talk about when she was cheating on me when she was pregnant and I had to get a paternity test to find out if Kinley was mine. We're not talking about any of that stuff, though. She just wants to slander my name. The problem is I could slander her name with facts, and she can slander my name with lies. That's what this boils down to.
Okay, thank you, Mr. Bondurant. Ms. Bliss, any reply?
There we go. Again, Your Honor, nothing has been provided to substantiate Mr. Bondurant's statements of sobriety, statements that CPS is closed and unfounded. Nothing even, frankly, from the police indicating that it is an active investigation to substantiate his series of events, which are unfortunately for him, contrary to the evidence that's been provided to the court. This isn't an issue of slandering one another, but I do believe that that's a big underlying issue between these parties' co-parenting relationships. And I think that that is borne out by the evidence that's been provided. It's an issue of safety and protecting these two young children, something that I don't believe Mr. Bondurant is currently capable of doing at this time. So we do believe that our requests are appropriate. We do believe that they are necessary in order to continue protecting these kids.
Thanks. Okay, I just wanted to circle back to that, the
And if
page
I can add,
limitation.
Your Honor, if I could just add one more thing.
Sure.
CPS came to this house and they were advocates for us keeping our children. Okay. I've asked for these records. Okay. I cannot make them work any faster, but what a lawyer can do that has no problem spouting off a bunch of wild, obscene comments that she doesn't know actually what she's talking about. She's literally just taking what Taylor Flick is saying, not even looking into it, not looking out for her client, because what's going to happen is I will be able to afford an attorney here soon down the road that will properly represent me. Okay. And this will be something that this is not going to be over with. I can guarantee you that when I have proper representation, okay, and I have someone speaking for me on truths, okay, Taylor's lies are going to come out and I will have full custody of my kids.
All right, thank you, Mr. Bondurant. I just wanted to circle back to the page limitation and just let Mr. Bondurant know where to find that. If you go to the Cowlitz County Superior Court webpage, which is cowlitzsuperiorcourt.us, and you look under rules, there's on the top left, one of the main headers, it says rules. And if you click on that, if you look at Rule 88, it'll give you the rule related to page links, so for future reference. So here there's a motion for adequate cause. Basically, has there been a substantial change for the court to look at making a change to the parenting provisions in the parenting plan that's been previously put in place? So here there's, obviously there's dispute between the parties as to what things mean or what's going on. As far as the DUI, we know that there was a prior DUI conviction in 2016. Apparently it was diverted. And so this current one, there's some ambiguity whether it was a DUI arrest or if it was some type of citation or what have you, and simply an arrest on a warrant. One thing I think is that rings loudly when you take into account the prior DUI in 2016, and then what Mr. Bondurant represented, that he said that, I believe, related to the overdose, that when I look at that overdose issue, even if I take Mr. Bondurant's statements at face value, which I do, he said that there was an individual that they didn't know, and they gave them a joint, and then they smoked it. And
Your Honor, it was one of my good friends' buddies. He knew him. I did not. So it was like we were in a circle, and a joint gets passed around.
Right.
And
right. So with the joint being passed around, it's fairly common knowledge in drug using circles that fentanyl gets laced with a bunch of stuff, including marijuana. So while the person there may be a friend of a friend, it's still placing confidence in that friend to vouch for this other friend that they got it from a clean source and there's no lacing is, at least in my opinion, reckless. Because it's very common knowledge that that happens with some regularity. So unfortunately, that occurred. Fortunately, the Narcan was administered, and thank goodness. Both parents, Mr. Bondurant and his spouse, are still here. That's a beautiful, great, good thing. But I take that overdose issue and the consumption of marijuana of an unknown source with the prevalence of fentanyl. I take that into consideration with what I call kind of this glorification of drug culture or drug consumption. I recognize that marijuana is legal. It is legal. Alcohol is legal. Food is legal. We abuse a lot of those things. Many of us abuse alcohol. Many of us abuse marijuana. Many of us overeat. Many of us do a lot of things. We don't get enough sleep. And some of those things that we do impact parenting. So I say that because those things raise a level of concern that there is this maybe an over focus, or maybe that there's been a lack of volitional control when it comes to certain substances, pardon me, and it may have an impact on parenting.
Your Honor,
Issue of sexualized, this isn't an opportunity for back and forth discussion. I've heard from both parties and I'm giving you my ruling at this point. So there's concern for sexualized behavior related to the French kissing incident. I read both parties, what you had to say about that. There's also issues related to, I'll leave it at that. So, there's also the issue of the driving license being revoked. And I recognize a lot of people that are revoked drive. In our size of our community, the size and distance between things, it almost becomes a necessity to drive. So I'm very aware that people who are suspended drive with regularity, if not infrequently. And Mr. Bondurant's own statement indicated 99% of the time I don't drive. There you go. So there's indications that if Mr. Bondurant were to drive and not be licensed and there were to be an accident, there could be some liability and concerns where the children may not be fully taken care of or provided for. That's a concern. That all leads me to believe that there is adequate cause. So I'll grant the motion for adequate cause to modify, pardon me, the parenting plan. There's also issues related to one thing I forgot to mention was related to, I'm happy to hear that Mr. Bondurant's currently in treatment for past abuse of prescription pills. That's great, that's important and noble and good, and I'm glad he's doing that. When combined with the other concerns, I think that a new SUD evaluation with collateralized input from Ms. Flick would be appropriate. So I'm going to require that. Pending the outcome of that SUD evaluation, the supervision with the girls and visits of dad will be professionally supervised. Once we get those results back, we can certainly or quickly look at that and change that if needs be. I will appoint a guardian ad litem to investigate the case. It'll be a county pay case. And they are to look into all issues related to parental, pardon me, the well-being of the children, including SUD issues, driving status, any of the number of concerns that have been raised here today. So that's the court's order at this point. Does any party have any questions?
Yeah, my only question would be, so from here going forward, am I just not allowed to contact my children at all? Because that's fine
No,
if you
may.
Hang on, Your Honor. Your Honor,
you may.
can I
Your
say
question, I'm entertaining questions at this point. Do you have a question?
Yeah, that's a question. I want to know how long you're going to keep me from my kids.
Yes, you can have contact with your children. It'll be supervised visitation.
No, like over the phone. I can't call
supervised.
my kids. I can't call my kids. I haven't talked to my kids in 4 months. That's not a problem. That's going to help with people's sobriety, Your Honor.
So So no need to be confrontational with me, Mr. Bondurant.
I'm not being
If
confrontational.
You are, and if you would like to have telephone contact with your children, you could say, Your Honor, what about telephone contact with my children? I'd be more than happy to entertain that question.
Your Honor, what about telephone contact with my children?
Ms. Bliss?
I don't necessarily think my client would have any issue with that so long as it's supervised.
I'm fine with telephone conversation between the father and his children. Pardon me, 3 times a week for up to 30 minutes. Do you have any other questions, Mr. Bondurant?
Sounds like you have more rights to my kids than I do. Nope.
Is that a question, sir?
No, I don't have a damn question for you.
Please refrain from swearing in my courtroom. The record will reflect that Mr. Bondurant exited the courtroom when I told him to abide by my rule. Ms. Bliss, if you'll provide a proposed order, and we will come back in 2 weeks.
Your Honor, I don't know, given his removal of himself, if you're willing to entertain this request, but with regard to those phone contacts, to limit the derogatory statements and conversations with the children, to obviously not include any litigation.
Given his inability to keep it together during today's hearing and his confrontational attitude and is quick to lose his composure, I'm revoking that permission. So there will be no phone contact until we come back again and we can have a discussion about his ability to moderate himself.
Very good. Do we want to set presentation for 2 weeks?
Yeah, let's set it for the 14th of November.
Very good. Thank you, Judge.
Great, thanks.
Oh,
We have 10 minutes left, and I have Betty Lynn and Jason Vane, and then the Myers and Myers matter. Ms. Baldwin turned her camera on just slightly sooner than Mr. Zandy.
That would be my preference.
Mine's gonna be quick, I promise, Judge.
Yeah. I believe that Ms. Bliss and I can keep our argument relatively tight as well.
I would agree.
Okay, let me just, okay. It looks like Mr. Bondurant's coming back on.
Okay.
One moment, please. All right, Mr. Bondurant, we lost you there. Oops. All right, Mr. Bondurant, we lost you there, and it looks like you're back on the line. Can you hear me?
Yes.
Okay. So as indicated at the time that you disconnected, I had asked you please to refrain from swearing in the courtroom, and then you immediately dropped off at that point.
Is that a question?
Nope, just a statement.
Okay. I dropped my phone. I called back.
And then after you had left the call, Ms. Bliss, help me remind me. I think you had made a request for something.
Some limiting language regarding the telephone contact with the children, just the standard refraining from discussing legal matters with them, speaking derogatorily of the other parent.
Okay, so I wanted to make sure, Mr. Bondurant, you heard that. And then do you have any comments related to if there were to be a restriction on the phone calls related to not allowing you to make any derogatory comments towards the mother?
No, I have no questions in regards to that. I have two questions though. So would that mean that the restraining orders are still in place on my children? Because I don't mind if there's one, like I said, if Taylor wants one. But how am I to contact my kids if I'm restrained from them? And then what would be the schedule that I'm allowed to call my kids so it doesn't get confused?
So as far as a restraining order, Ms. Bliss, do you have any information about that?
And Your Honor, at this point, given Your Honor's ruling, I think so long as we have some very clear language in there as to types of behavior, that at this time, restraining order is no longer necessary.
Go, dude.
Okay, so the restraining order is hereby rescinded. It's no more. And then there was also in your absence, Mr. Bondurant, there was a discussion related to your lack of moderation in the hearing. And I made a decision without you being present that the phone calls were not going to continue that I had just granted earlier. My basis for doing that was that I found your behavior toward the court to be somewhat presumptuous, aggressive, and kind of defiant in a way. Certainly people disagree with my rulings, but they do so in a moderated way. And I was concerned by what I deemed to be the dropping of the call. I didn't think it was a drop of the call. I thought it was a termination of the call by you just being frustrated.
Why would I call back
let's
then?
go ahead and talk about that. Let's talk about the phone calls. You indicated that you're still interested in having those phone calls, correct?
Didn't you say you were just rescinding the offer?
I indicated in your absence, that's what I did. And so now you had indicated you wanted to talk about the days and times of the phone call, so there wasn't any question. So I'm inclined to reinstate those.
It seems he may have dropped off again.
Mr. Bondurant apparently dropped his phone again.
And he's back.
It's like you're back, Mr. Bondurant.
Yes, I'm not hanging up intentionally. No, I'm in a car and it keeps dropping the calls. I didn't hang up the first time. I lost my cool, absolutely. But no, I'm not hanging up, but that's fine. Yeah, I'm asking about a schedule, Your Honor. What days
we're
I can
talking
call my
about
kids.
phone call schedules. Do you have a proposed schedule that you would prefer?
Nope, whatever suits best for Taylor's needs.
Could we look at maybe, I'm not sure, maybe sometime just right after dinner, Monday, Wednesday, Friday?
Whatever you want, Your Honor. Whatever sounds good to you guys.
Ms. Bliss?
I'll confirm with my client. I don't imagine that would be an issue. If it is, I'll make contact with Mr. Bondurant if he chooses to reply. That's on him.
Okay, so let's do this. Monday, Wednesday, Friday, 7 p.m. up to 30 minutes. And if the parties agree to something different, great, they can do it different. But if they can't agree, then it'll be Monday, Wednesday, Friday, 7 p.m. Okay, so I think those are the issues that we had discussed in Mr. Bondurant's absence when he dropped off the first time. Oh, and then also we said what's called a presentation date, November 14th, Tuesday at 9 o'clock will be the presentation date. That's where Ms. Bliss will summarize the court's rulings, oral rulings today, and put them in paper. She'll send a copy to Mr. Bondurant, and Mr. Bondurant has any objections to that, or he feels that the court didn't get it right, then we'll be here on the 14th to discuss that and work it out. So any questions?
The only remaining issue, Your Honor, is to getting the next 3 names for the guardian ad litem.
Repeat that again, please.
Sorry, the next 3 names for the guardian ad litem. I don't think we did that.
Yeah, thank you. So in choosing the guardian ad litem, I appreciate that. The clerk keeps a list of the next 3 individuals who come up on the guardian ad litem list. So I'll ask the court clerk to read the next 3 names, please.
The next 3 names are Heather Kell, Amy Turnbull, and Ann Height.
Okay, and with that, so with those 3 names, each party has the right to strike 1 name. So Ms. Bliss, do you have any strikes?
I do not, Your Honor. I'm fine with Ms. Kill.
Okay, and Mr. Bondurant, you have the right to strike one of those individuals. Would you like to strike any one of them?
Nope.
All right, Heather Kell is appointed. And she will reach out to the parties, and then please make sure that you respond quickly to her. And the sooner you respond, the sooner she can get going on the work and get information to the court. All right, so we'll be back on November 14th at 9 a.m. for the presentation. Thank you.
All right, thank you for your patience. Next, I have Taylor Flick and Isaac Bondurant, cause number 21-3-194-08. Ms. Bliss is present, and I see that let's ask if Isaac Bondurant, if you're on the line.
Yes, Your Honor.
Okay, welcome to you, Mr. Bondurant. And it looks like Ms. Looney, are you involved in this case also?
We are, Your Honor, but it's my understanding that there's no child support order being entered today.
Great. Thank you. Appreciate you chiming in. All right, so we're here on today on a presentation from an earlier court hearing. This is from October 31st, where we had a hearing and the court made some rulings. I have proposed orders that have been prepared by Ms. Bliss. There's three orders: an order on adequate cause to change a parenting plan, and then I also have a parenting plan, and also an order appointing a guardian ad litem. Mr. Bondurant, did you receive copies of those documents?
Yes.
Okay. And do you have any concerns that those orders fail to reflect what the court ordered on that day, or any other concerns related to those?
Yeah. Your Honor, I was actually going to see if we would be able to postpone. I'm going to be looking for seeking representation. Okay. The funds are there now. So I have clearly made a mess of the situation. I haven't made the situation any better with you. I'm just shooting myself in the foot. Anytime I basically talk, I feel wrong or right. So I'm just going to do my best and invoke my rights, shut my mouth, and get an attorney.
Okay, so you're asking for this hearing related to proposed orders to be continued until you have the attorney on board, correct?
Yes, Your Honor. And then I was also, aside from that, I've been awarded 3 30-minute phone calls. I just wanted to touch base with you a little bit on that because there was some clear confusion. I was hung up when my wife said hello to the children, and I was told that you said specifically only I could speak. My other child has been hung up on, and I was also going to touch base. I haven't seen my children in months. I was going to see if there's any way I would be able to FaceTime them, as they are also asking to see my face. That's
all right. Let's go ahead and take things one at a time. First, let me hear from Ms. Bliss related to the proposed orders of the adequate cause, the guardian ad litem, and the parenting plan.
And Your Honor, I believe that my orders accurately reflect your rulings on October 31. Mr. Bondurant didn't ask for an attorney at that point. We proceeded with the hearing. We proceeded with the hearing. I prepared orders to that effect. To now request an attorney before these orders are entered is essentially just delaying the process. You did appoint a guardian ad litem. Ms. Kale does need to start her investigation, so I would ask that the orders be entered today. And then I can address the phone call issue afterwards if you'd like.
Thank you. Yeah, let's proceed in that fashion. So the first order, proposed order, is the order on adequate cause. That's an appropriate ruling, and so I'm going to sign off on that. And I don't think that it needs to be continued because the court's already made its ruling. Another attorney comes in and would look at that, and I'm comfortable signing off on that because that's exactly what happened. I made a finding of adequate cause that there's enough of a substantial change there to allow for a modification. So I'll sign off on that. And then the guardian ad litem. That's an order that is appropriate also to be entered at this time. That's what I did. I ordered that there be a guardian ad litem appointed. I did make one change to the proposed order on page 2. We're looking for the interim GAL report to occur on January 16th of 2024. I just changed it from 23 to 24. So I'm going to sign off on that. It's a county pay case, so neither party will have to pay for it. So I'm going to sign off on that and deny the request to continue. Then, as far as the parenting plan, the parenting plan, when I reviewed it, it accurately captured what I ordered on that day and from October 31st. So, I think, in response to Mr. Bondurant's request to set the matter over, I think I've seen this pattern happen numerous times where a hearing will happen and then the request is set over and then a new attorney comes on and they listen to the hearing on video or audio, and they find that the proposed order as presented was exactly what the court ordered, and then they sign off on it. So that's typically what happens. If there's ever a need to change it in the future, if there's a change of circumstances, certainly Mr. Bondurant could address that through motion through his new counsel. Otherwise, I find that the order as presented captures what the court intended it to capture. So I'm going to sign off on the order. All right, so if either party needs copies of those proposed orders, you can get those copies from the court clerk. As far as the provision related to phone calls, I indicated that the phone calls could be up to 3 times per week, Mondays, Wednesdays, and Fridays at 7 p.m. or 5 p.m. I think I said 7. And it could be up to 30 minutes. Now, Mr. Bondurant had a question related to that and shared his input on that. I don't think I fully heard from him. So we'll hear from him a little bit more and Ms. Bliss. Mr. Bondurant?
Yes, Your Honor.
You're addressing the issue as far as phone calls. Could you just kind of give me just maybe either repeat what you said before or expand what you said?
So my daughters have asked me to FaceTime them. Taylor Flick said the only way she would agree to that is if I did it over the app through the courthouse. I just feel that's treating it a little bit too much like there's a restraining order, which there isn't in place. But she said basically no to the FaceTimes, and anytime that my child or my wife says anything to the kids, I am hung up on. And I was told that you specifically said that it was just me to talk to. So I was hoping if that was the case, that at least during this time that my other children, my wife, would also be able to talk to them, seeing as they have been in their life for years already.
Thank you, Ms. Bondurant. Ms. Bliss?
Your Honor, I think with the issue of other folks on the phone, I think it's my client's understanding that Your Honor ordered this to essentially be visitation between dad and the children. So she was hoping to limit the phone calls, at least at this time, to dad and the children to continue to furnish that relationship and that visitation.
Okay. All right. Thank you. All right. So Mr. Bondurant is not an unusual request. It seems like a reasonable request to allow, people that know the children, love the children, to have communication with them. The order that I entered allowed for specific communication between father and children. And I also appointed a guardian ad litem to chime in, and she's going to chime in sometime in mid-January. And so while I'm sensitive to the need for all individuals that have a relationship with the children to continue to build that relationship, I'm going to hold off on it for this time and have the focus be the time between father and daughters, and that can be the focus for now. And also I'll just make mention that the intent of the court is to allow a free communication with the father and the daughters. There shouldn't be any untoward or extra restrictive activities on the mother's part. The idea there is that father's to have this good, solid time with his daughters, and it's not to be unduly restricted or prematurely terminated for reasons that may not amount to as big a deal as they seem in the moment. So with that said, as far as the FaceTime, Ms. Bliss, did you have any comment related to that request as opposed to phone call?
I don't have a position on it. I think I don't think my client would have any objection to that if Your Honor ordered it.
Okay, I think FaceTime is good to have that also. So it's telephonic contact, and I'll put or FaceTime or related video, or yeah. So I'll just put or FaceTime /video. So I've added that onto page 2 of the parenting plan. All right, so I think I've addressed those issues. So I've signed off on the proposed parenting plan. Any additional questions, Ms. Bliss?
Your Honor, I did want to ask that you instruct Mr. Bondurant to keep these discussions with the children appropriate. I do know in my parenting plan, I did include language in there that said specifically, don't speak derogatorily towards about the other parent in front of the children, and don't discuss litigation with the children. My client has indicated that several times during the phone calls, which often prompt her terminating phone calls early, Mr. Bondurant has essentially told the children, I'll square this way with the judge. Your mom doesn't want me to see you, things of that nature. And I think obviously that's detrimental to the children and completely inappropriate, frankly. So I would just ask that Your Honor kindly remind Mr. Bondurant to cease that behavior moving forward.
Thanks, Mr.
Your Honor. Could I speak on that, Your Honor?
Please.
Okay. So what had happened, and I made sure because I am recording my phone calls with the kids because I have been hung up on. I don't see, my kids are asking me on the phone, why can't I see your face? Can we see your face? For the first 2 visits, I said, I just redirected the question. And on the third one, I don't feel through all this, I should have to lie to my children. I said, your mother does not feel comfortable doing video calls right now. We will get that all squared away soon. I don't know what else I am supposed to say to my 4- and 5-year-old when they're asking why they can't see daddy, when that's what they're used to. I'm not just going to tell my kids, make it seem like I don't want to video call them. That's not what I'm going to do. Whether that's what the court requests me to do, I won't do that.
Okay. All right, thanks. So I think it's, we've settled the FaceTime issue, the FaceTime that can happen. Also, just there is a provision within that parenting plan as far as derogatory comments that one parent speaks to the children about another parent. I'll just tell you my view on that is that when children love both parents, they are loyal and faithful and love both parents, no matter what's happening between the parents themselves. And when a child feels that one of their parents is being attacked or being spoken of poorly, it's a direct attack against that child. The child feels loyalty. They want to protect that parent. And in a way, it damages and attacks them because they are a part of that parent. Their identities have not yet been completely separated. So when one parent says something negative about the other parent, the children internalize that and it negatively impacts them. And some kids it impacts more than others. So just caution all parties related to that. Then also as far as litigation, I think sometimes parents, are kind of at a loss of what to say. Is like, well, this can't happen because we have to take this to court or the judge has to decide on this. So that's one thing that we try to shield children from, the discussion of litigation. And there's creative ways to explain those to children and say, right now we can't talk about that, or we haven't figured that out. We're working on that, and just leave it at that and not talk about the litigation. And because that's way over little 4- and 5-year-olds head. And so that's just, you can just say that's kind of an adult thing and we're working on it. And just that helps the children to feel like, because sometimes kids feel like they're in charge and they have some responsibility to help work things out. And that's a really unfair burden to put on kids. So just encourage the parties to not discuss that litigation or court or anything like that, and just free the kids up from having to bear that burden. So with that, I appreciate everybody's help. I've signed off on those proposed orders, and that'll conclude the hearing. Thank you.
Thank you, Judge.
421-3-194-08 Flick v. Bondurant.
That matters already. Carly was appearing on behalf of Taylor Flick.
Okay.
Their Kale guardian ad litem, Your Honor.
Okay.
I'm here, Your Honor.
Okay, you need to identify yourself, please.
Mr. Bondurant.
Okay. All right, so this matter comes on an order appointing on November 4, 23. It was county pay. So can you tell me where things are at this point?
Yes, Your Honor. Thank you. I've had the opportunity to meet with Ms. Flick. I've had quite a bit of communication with her. I've also had quite a bit of communication with Mr. Bondurant. I've had an interview with him for a couple of hours, and I spent some time at Ms. Flick's home. Through no fault of his own, Mr. Bondurant and I have not been able to get time for me to come to his house, in part due to the most recent weather event. I have been provided videos of the girls and have appointment to set up to go spend time at the home with them. I also am going to be spending time with the girls at their school. At this point in time, I've requested that Mr. Bondurant go get a hair follicle test to demonstrate where he's at in terms of substance abuse. He's agreed to do so, and let me know that right after his next paycheck, he'll be able to take care of that. The biggest concerns I'm hearing from both parties at this point are based in communication during the digital phone calls. Mr. Bondurant's concerns are that he's not getting accurate communication. Ms. Flick's position is that the children are, one, they're extraordinarily young to have a long-term ongoing conversation via Zoom, but also the younger daughter, Kinley, has just recently been evaluated and screened into the WISE program. She's going to be experiencing about 12 hours a week of therapy, behavioral specialists, speech work. Both of these girls have experienced quite a lot of trauma in their communication with their father. I understand that Mr. Bondurant's intentions are very good. His heart is that he wants to be close to his children. However, at this point, the children's experience of him and in Mr. Bondurant's home has been fairly traumatic. The older daughter, I've seen video of the older daughter waking up in the night, afraid that her father was going to kidnap her and take her away from her mother. I do believe the children are doing their best to communicate with their dad at the scheduled times. I do not believe that they are ready to have more interaction with Mr. Bondurant at this point in time. The one thing I would ask Your Honor to maybe put into an order is that Mr. Bondurant follow through on this hair follicle test and be able to demonstrate where he's at in terms of substance abuse. The other thing I would request is that the girls not be required to refer to his wife as Courtney Mom. The girls are very upset by having Mr. Bondurant insists that the children call her Courtney Mom instead of just by her name. And they are very concerned. The girls have expressed that they're worried they're going to get in trouble with their dad or be punished for not using that language. And it impacts their ability to want to speak with him because they're scared of his reaction if they don't use the language that he requires of them. I would ask that Mr. Bondurant, and I've, communicated that what Mr. Bondurant needs to do is breathe heavily, accept what the girls are able to provide for him at this time, and give them some space to get into this counseling program and start working through some of these issues. The next phase of this investigation will be, like I said, spending time with the girls in person at school and in their home. And I am going to do a home visit to Mr. Bondurant's residence and spend some time there, get to know his wife and see where everybody's living. And then I should be able to complete this report on time and have it filed.
Before I move on, I want to make sure that everybody understands this is a family law A docket. And there, if you were looking to be on the protection order docket, this is not that docket. You can go back to the Cowlitz County Zoom links. There is a Zoom link for that protection order docket. So I just want to make sure people are in the right place. Okay, Ms. Bliss.
Thank you, Your Honor. I don't have much to provide today. I would ask the court that the hair follicle be ordered. I don't know if you looked too far into the file, but it was a request of my client initially that a substance abuse finding under 3B be found. Judge Evans at the time reserved on that finding in hopes that we could get some more information from Ms. Kale. I think the fact that she still has those concerns, still wants, maybe not even concerns, but wants Mr. Bondurant to be able to show at least a baseline. I think that that's appropriate. So I would ask the court to order that today. At this point, I don't have much else to say other than I would ask the court to also consider the recommendation of Ms. Kale as it relates to the referring to the stepmother as Courtney Mom. I know the court typically doesn't enter these types of orders unless it's necessary. I would say that with the concern that the guardian ad litem has raised, I do think at least it's appropriate, at least as of right now, given the trauma that the girls have experienced. But other than that, I don't have anything else to add today. I would just ask that we maintain status quo until we get that final order.
All right, Mr. Bondurant,
Yes, Your Honor.
anything you wanted to say?
Not at this time.
Okay. So with that, I will go ahead and order that the dad get the hair follicle test within the next 72 hours. No dyeing of the hair, no cutting of the hair until that is done. And if you need, well, where are you actually located?
Lexington.
Okay, so you're here locally. Okay. So Ms. Bliss, or the guardian litem, actually, if you could provide some places that he can go to get that done, please do so. And then in regard to the wife of the husband at this point, that's a very difficult thing for children, especially with changes and trying to work with them. The best thing, as it has been indicated, is not to force them to do something, give them time, see where they go with it, but asking them to call someone that they don't feel comfortable calling that name. So at this time, I'll go ahead and do the order. As Ms. Bliss indicated, I don't like to do that, but where it's making the children so uncomfortable, that would be appropriate. So Ms. Bliss, can you prepare an order to that effect?
I can, Judge, yes.
Okay, get that processed and just get it to me for signature. And then the next review, let's see, I was looking at it yesterday. Yeah, of course I can't find it back again.
I believe it's March 19th, Your Honor.
March 19th, yes.
Okay, next review then March 19th. If anything comes up before that time, then either party can obviously note it up for coming before the court.
And Your Honor, I just want to make sure Mr. Bondurant knows to sign the appropriate releases of information for his hair follicles.
Oh, yes, thank you. So Mr. Bondurant, to make sure that everyone gets notice of what the test results are, you will need to sign release of information where you go for that hair follicle test. You need to sign the release for Ms. Bliss's office as well as the guardian ad litem, and so that they can receive a copy as well.
Okay.
All right.
Thank you, Judge.
All right.
Thank you, Your Honor.
That concludes the matter for today. Number 5 on the docket, 21-3-00194-08. That's the Flick the Bondurant matter.
That matter's ready.
It'll be just a minute. Okay, we have Miss Bliss. Do we have Isaac Bondurant present?
Yes, Your Honor.
Okay, thank you. And do we have Heather, is it Call? Is that how you say your last name?
It's Kale. Thank you, Your
Kale,
Honor. Good morning.
okay. All right, so I did not see a guardian ad litem report. So can you tell me the status of that?
Absolutely, Your Honor. So the report's actually almost finished. My intention was to file.
You muted. You're muted.
Actually had his substance abuse evaluation as it was ordered by the court. However, it had not been filed with the court or provided to me or Ms. Bliss. And I recognized in the parenting plan that had that been filed, because it does not recommend treatment for him, he could have been having supervised visitation with the kids. And so I encouraged him to make sure that that got done. We also realized that Ms. Flick was not able to give the collateral input that was required by the court. And as I understand it, Mr. Bondurant went down today or called the facility today and asked them to reach out to Ms. Flick so that she could give that input. With all of that, and I also have not, the mental health professional that the girls have been working with has not returned my outreach yet. And I feel like until I have that output and I get a little more information from the substance abuse evaluation, as well as maybe a visitation or two from Mr. Bondurant, I'd like to extend the deadline so that I can get that information before we file.
Ms. Bliss?
And Your Honor, most of Ms. Kale's statements to the court this morning were brought to my attention yesterday. I also was unaware that Mr. Bondurant completed his evaluation. My client did not provide any collateral input. She was not contacted. So that obviously needs to be remedied. I agree that Ms. Kale should probably have that information, have some information. If visits do resume, the girls are simply having phone calls with Mr. Bondurant at this point. So I think in order to get the clearest picture for a final GAL report, I think it's beneficial to extend the deadline.
Ms. Bondurant? Anything?
Yes, I agree. I would just, if at all possible, as soon as we could get a court date at the earliest, that's all I'd ask.
Okay, well, this is a lot depending on you and well, I guess you did your evaluation, so now it's a matter of getting the input that was supposed to happen. So with that, Ms. Kale, what are you thinking as far as how long it'll take you?
I was hoping that we could have our next court date. I mean, if he can get that collateral input taken care of, and we can get a visit or two, his visitation supervisor is going to be Beth Fellows, who I think is a really important asset to this information. So if we can get a visit in and some collateral input from Ms. Flick for that evaluation, I can file this report, and actually we could have a court date on April 23rd, if that works for everybody.
Ms. Bliss?
That works for my calendar, Judge.
Mr. Bondurant?
That's fine, Your Honor.
Okay, so do you know who you need to contact? Hold on. You know who you need to contact for visitation?
Yes, ma'am.
Okay, so go ahead and get that contact made so you can have your visitation, okay?
Okay, can I say one more thing, please?
Go ahead.
So when I called the Family Health Center about my SUD, they just allowed me to know I just need to go down and fill out an ROI, and then Taylor can call them, but they don't call people or reach out. She'll have to reach out to them after I've filled out the ROI.
Okay, so I want you to do that today. And then Ms. Kell, you'll need to contact them today, as well as your client, Ms. Bliss.
Yes, Judge, and she's present on Zoom today, so she has that information now.
Okay.
And I would, if I can make the request, Your Honor, that Mr. Bondurant add me to the ROI as well, that would be really helpful.
You're already on it, Heather.
Okay, excellent. Thank you.
All right, what date were you asking for? April
23rd.
Okay. All right, so we'll go ahead and set another final review over to April 23 at 9 a.m.
Thank you, Judge.
Thank you, Your Honor.
Number 8 on the docket, 21-3-00194-08. It'll be just a second here. Click and Bonder. All right, again, number 8, 21-3-00194-08, Flick v. Bondurant matter.
That matter's ready.
All right, this matter is on for a final GAL report. We have Ms. Bliss. We have Ms. Is it Call? Okay, Ms. Call. And do we have Mr. Bondurant?
Yes, Your Honor.
Okay. So the only thing for today was to make sure that the final report was done. It was filed on April 18. So with that, is there anything further from anyone?
Nothing for me, Judge. I can, I agree that it was filed on the 18th. I did receive that document and I have not had the opportunity to discuss that with my client. So I would ask that the court just strike the matter today.
Mr. Bondurant?
That's fine.
Okay. All right, so the report's been filed, nothing further needs to occur. And we'll just go from there.
Thank you, Judge.
Thank you. All right, any other agreed continuances?
Yes, Judge. Number 3, the Flick and Bondurant matter. I received word this morning that Mr. Bondurant's wife has just gone into labor and that he's in the hospital right now with her. I don't imagine he's present. There was an agreement to set this over a week or 2, depending on the court's calendar.
We can go 1 week if you like.
Okay, that's my preference. Yes. And then I'll be in touch with him. And if that doesn't work, we can set it over again.
All right, we'll continue that to June 4.
Thank you, Judge.
We can see from Odyssey that the hearing on June 4th that they were scheduled to have was stricken after both sides agreed to stipulate to its cancellation. My guess, and it's just a guess, is that both sides were happy with the JL report and were willing to adopt it, and often when both sides agree to something, they can have it dealt with off docket. There's been no sign of them since, so it seems like whatever custody arrangement they've got going on right now is working out for them. I know Miss Call is excellent at her job, and it would not surprise me if she had recommended some sort of graduated plan to restore his visitation back to more like what it had been. I do hope Dad takes some time to reflect on his actions and how he handled himself in this case, and that he does something different next time. His childish behavior both in and out of the courtroom did him no favors, and it certainly wasn't in the children's best interest. I wish them all a bright future. See you next time.